Your moderator, Peter Kraybill, for navigating uncertain finances, non-bankruptcy and pre-bankruptcy planning alternatives for small businesses. We're going to start the webinar now. This is coming to you from multiple homes where we are each as panelists and as moderator are having our video stream on Zoom. I assume many of you are already very familiar with Zoom meetings by this point. The details for today's meeting, we're going to cover about a 90-minute presentation and include multiple subtopics. We're going to have a total of 8 slides today, and we have an expectation of more than 3 dozen participants. The seminar that we're doing is going to be recorded, so that this also will be available at the panelists' own firm's websites. So that should be available to the panelists that you know. We also are pleased to have panelists from a variety of expertise and background areas with bankruptcy and creditors issues. And we'll get started here just momentarily. We do have a couple more folks joining. Good afternoon. This is our Navigating Uncertain Finances, Non-Bankruptcy and Pre-Bankruptcy Planning Alternatives for Small Businesses webinar beginning now, and we welcome you to this presentation. We have a group of panelists that will be presenting here today. I am Attorney Peter Kraybill with Gibble, Kraybill & Hess. I'm moderating this seminar as a panel today, and we've organized this into sections, organized by questions for the panel. You are also able to ask questions and make chat comments to us as the host. So if you see in your chat dialog at the bottom of your Zoom screen, you can chat and you can chat directly to the host. That's how we will take additional questions. However, we've also structured this webinar so that the questions are in fact the organizing principle. The questions are grouped by sections, and we have a slide for each section set. If you do have a question, please go ahead and ask that via chat to the host. I will see your question. We will share that, and we can take selected audience comments from you as participants to the panel. Although your identities are visible to me and to the host, video is generally turned off, except to the panelists. So without further ado, I'm going to share my screen again so that you can see the presentation. And the panelists that we have here today are Polly Gibble, a bankruptcy and debtor creditor attorney of Saxon & Stump, who is also a former judicial law clerk. Donald Hess, a debtor creditor attorney of Gibble, Kraybill & Hess. Raymond Lemish, a bankruptcy and debtor creditor attorney of Claire Harrison Harvey Brandsburg LLP. Robert Ponce, a bankruptcy and debtor creditor attorney of Brubaker, Connaughton, Goss, and Lucarelli. And Barry Salatke, a bankruptcy and debtor creditor attorney of Saxon & Stump LLC, as well as a former Chapter 7 trustee. The outline of our presentation today, we're going to go through these 8 topics as separate slides. So each of these 8 topics will be addressed individually through multiple questions that I will pose to the panel, and then the panelists are prepared to answer those questions. As a general overview of why we're gathering here today, there are some economic and financial parallels now for businesses in the COVID pandemic crisis to the foreclosure crisis that occurred in 2008. After all, businesses do have cycles of downturns, but the current crisis is more in the nature of a black swan event. Unlike in 2008, when some individuals were hurt because they couldn't pay their mortgages, but most people did not feel a huge impact on their ability to pay bills, now, in contrast, many people not only have portfolios dropping in value, but their businesses also have lower cash flow or possibly no income. Our first prescription is don't panic. We know that the government and big banks are likely to take the biggest financial hit in the current economy. However, most small businesses are likely to be next, hurting financially in these times. Small businesses should focus now on defining what they are still in business to do, how you and your business will indeed survive. This presentation is hopefully to aid in defining those goals, and you should be focusing on what you're still in business to do. We will help you as business leaders. As you may see your business have diminishing cash, you may not know what to do or where to turn, and indeed a lot of your business creditors don't know what to do either. And particularly if a business debtor becomes insolvent an unsecured creditor, as well as the owners of the business, are likely to have a lot to lose. So without further ado, we're going to go to our main panel and to the outline that we prepared. The first topic that we're covering is the alternatives of a business debtor when a creditor requests payment. And in regard to this, we have the first question being, how does a business debtor survey the field when facing financial stress? And I'm going to turn that presentation question over to Ray Lemish. Ray?
Thank you, Peter. I think the first thing I would say is what you've already said, which is don't panic. I think that the business person, the person operating the business, first needs to look at the creditor demands that it currently has and the ones that it knows it will have in the near term. And by that, I mean, do you have specific creditors that are knocking on your door? Are you late to your creditors? Are you not able to pay certain specific creditors, such as your taxing authority or your payroll, your landlord, your bank? But you need to figure out what it is that to whom you owe what and when those amounts are due, to see if there's a cash flow way of dealing with things. So the first thing is you have to look around and figure out how much cash you have and where those cash needs are most important. And in doing that, you're going to have to sort of sift through the different types of creditors that are out there. I mean, the general two categories of creditors are secured and unsecured. Secured creditors being the creditors that hold some sort of collateral, more so than I would say a guarantee. I'm thinking about hard collateral, inventory, have liens on receivables, mortgages, things like that. And those creditors generally are the ones that you pay attention to, because they can take action that can create the most harm in the shortest period of time for the company. But in fact, you may have a critical vendor out there that you need, and if you don't source the critical vendor properly, and if the critical vendor gets upset, then in fact you're going to have just as much of a problem as if you didn't pay your bank. Frankly, critical vendors tend to be less tolerant and less patient than a bank might be. So I think that's what you initially need to do, which is look and see what your demands are and figure out exactly what your cash flow is, and then start addressing which creditors you pay at what time.
Thank you, Ray. And in terms of defining who you pay first or in which order, we're going to turn to Bob Ponce with our next question. Our next question simply is, are all creditors created equal? Bob, can you speak to that?
Sure. Clearly, when a business is struggling, all of its creditors are not equal. Ray just alluded to certain classes of creditors. Secured creditors probably merit first attention because if you're talking about your principal lender, a bank or a financial institution, they probably have liens on all of your assets, or you may have secured creditors who have particularly financed critical pieces of your business equipment or perhaps your inventory. Those creditors have rights that others don't to specifically seize their collateral and dispose of it if you're in default and they're not satisfied with arrangements you have made. So that your secured creditors are one group that needs to be at the top priority-wise. If you're renting your principal business location, you obviously need a place to conduct business, so you need to prioritize your landlord. The critical vendor suppliers that Ray mentioned are particularly important. If you're running a restaurant, for example, you obviously can't conduct business at all if you don't have food to serve, liquor to pour, and so forth. And finally, I would just mention taxes, certain types of taxes, particularly trust fund employer withholding taxes, sales taxes. If they are not paid, in addition to incurring really staggering penalties, you run the risk of individual principals with the business incurring civil or potentially even criminal liability.
And Bob, if you're looking to paying your creditors and a creditor asks you for cash on delivery, say, how should you treat that type of request?
Well, if it's a critical vendor particularly, that may be the only way to get them over the fact that your delinquent account is growing. It wouldn't be my first choice because obviously it uses a lot of cash. But if it is a way to satisfy certain particularly critical vendors at a time when you're simply not able to keep up, it may be a useful accommodation to offer.
Thank you, Bob. Moving to our next question, we have the issue of judgment creditors, people who have sued the business and perhaps have obtained a judgment successfully against the business, or if they otherwise had the right, for example, to confess judgment or have obtained a judgment in some other means. Don Hess, if you want to take that question, how would you deal with those creditors that are judgment creditors?
Sure. Well, I would like to engage those creditors before they reduce their claim to a judgment, to be sure, because then you have good negotiating position. If it's an unsecured creditor, it's not likely that there are any assets that are going to be available for a judgment creditor when they come to execution on the judgment. So hopefully you'll be able to negotiate some kind of forbearance agreement or modification to the satisfaction of those creditors. Another class of creditors would be your subordinated creditors. They're not likely to move against you if they are in second position to a primary lender and their lien position is junior. They probably would already have had to give the primary lender a subordination agreement, so they're gonna stand still. If, however, you do end up with judgments against you, you can be vulnerable because that judgment creditor could force you into filing bankruptcy, or could even file you involuntarily in an 11.
Yeah, thank you, Don. So looking then to how you would move forward if you're not under the immediate threat perhaps of a lawsuit or having a creditor pursue remedies against you. Ray, if you could speak to the next steps. What do we do in a month or in 3 months? How does that evolve for the debtor?
I think that once the immediate fires have been put out and you sort of have an operational plan as to how to move forward, at least in the short term, I think the next thing that one needs to do is to figure out what are the causes of the problem. These days, many of the causes of the problem can be traced back, obviously, to the pandemic. But that's not always the situation. And in fact, even in this circumstance, it may not be the complete answer to the question. So one of the things you look at is, all things being equal, is the financial condition of the company improving? And if it's not, why isn't it? Is it an organic or a systematic problem? And by that, I mean, is there a specific issue that's causing a problem? Are you paying way too much on your lease? Maybe you don't need as much space as you originally thought. Are you having a problem with an insurance claim? You had a loss and the insurance adjuster hasn't come through and hasn't paid, and therefore there's a chunk of money that you're sort of missing. Or is it that you're not properly pricing your goods? Are you not in the right markets? Is your market share too small? There may be a variety of factors, both endemic to the company and external to the company, that need to be checked out. And I think that it all sort of goes down to the question of, is the business viable? Can it be fixed? And if it can be fixed, how does it get fixed? And what's the process you may go through for that purpose?
Yeah, thank you, Ray. If we're getting to that period where we've identified indeed what is ahead for at least the next month or two, then how are we approaching what do we do as we see our cash dwindle away as a business holding perhaps limited cash? How should we allocate those resources? Bob, would you want to speak to those issues?
Sure. What I have to say is applicable to your bank, your principal lender, if you have one, and also to general trade creditors. But speaking most directly toward your bank, what makes lenders the most edgy is uncertainty. Since we don't have any bankers on the panel, I'll take a shot there. It's no coincidence that bankers typically are the ones still wearing gray and blue suits to work. They want to know what they're dealing with. Lending officers obviously want all of their borrowers to be succeeding, but if there's a problem, you are much more likely as a borrower to get a positive reaction and develop a working outcome if you let your lender know before it's a crisis, rather than wait until your relationship manager is in a meeting and somebody asks him what happened 3 or 4 months ago and why is this borrower so far behind, and they get called on the carpet, and then they're coming back to you. By that time, you'll have burned up a lot of your goodwill. So banks will assume, and other types of creditors as well, they will typically assume the worst of silence. So while I understand the tension of not wanting to spook your lenders if things are looking bad, I think it's generally very important to try to head off a crisis rather than to just let it ride and hope that no one notices and you can fix it. Particularly in these present times, everybody is hurting, so it shouldn't shock any lender or any creditor of any consequence that you might need some accommodation for a time.
Thank you, Bob. So as we toggle back and forth between the issues of trying to take a longer view, but also managing short-term cash or cash flow and looking for immediate solutions to financial problems, Don, could you tell us about how we should toggle back and forth on those immediate solutions versus taking a longer view?
Sure. Well, we've already heard conversation that really speak to this issue of planning rationally. Obviously, you don't want to empty your whole pocketbook to one particularly voracious creditor that's beating on your door. There are some things you can put off. Real estate taxes, you're never going to avoid. The property will never avoid that lien, statutory lien, but you don't necessarily have to pay something like that up front when cash is at a premium and precious to you. But other than that, Peter, really every situation when a business is at this state of health or tension or distress, it becomes very fact sensitive in terms of how you're going to play your cards.
Yeah, fair enough. Indeed, very fact sensitive. But the question, as we're looking at how do we move ahead and what advice an attorney, particularly a bankruptcy or collections or creditor attorney, would be looking at for how a debtor could plan. Ray, could you speak to what would be some of those points of advice that that a debtor should be hearing from their attorney, or that attorneys should offer to debtors as they're planning ahead at this time?
Attorney to do is to make sure that the debtors are thinking through things logically and in a lot of ways dispassionately. So they need a budget. We've talked a little bit about that before, but in order to deal with financial issues, you need a budget. You need to know what your expenses are and whether they peak at different points, and if so, who is owed the money, which creditors. One thing that I often advise, depending on the circumstances, for the company to find some sort of outside professional help. And by that, I'm not talking about psychiatric help. I'm talking about business professionals that whose job it is to come in and analyze a company and ascertain ways the company can save some money, maybe open up markets, maybe expand its product lines and things like that. So essentially, a business analyst who can come in and help the company. They also have crisis managers who will do the same sort of thing. It's the same idea. And then you need to pay attention to your expenses and make sure they're sort of right size for the amount of business you're doing. Do you have too much overhead? Do you have too much payroll? Do you need to reduce payroll by eliminating positions? Not an easy decision to make, but again, this has to be done dispassionately. And during the course of doing all this, of course, the company has to be careful not to get itself into greater troubles. That would be, I think, as Bob had alluded to before, the idea of ignoring trust fund taxes and other withholding taxes that could come back and haunt the insiders at a later date. Make sure you're paying your insurance premiums And if you choose not to pay, then make sure you're aware of what risks you're now facing if you don't have insurance coverage, depending on what that insurance coverage is. And then the other thing you need to do is you just need to start looking for financing sources. Is there a way to go back to your current bank and ask for an additional line of credit, to expand your current line of credit, to get a term loan? Are there other financing sources out there? Do you have friends, family, third parties that may want to come in, that may want to lend money? Perhaps they're willing to buy a piece of the business. It's always a possibility. So I think it's a multitasking job of looking and identifying problems and figuring out where you're going to be able to get more cash if you need it.
Thank you, Ray. And when we're talking about lenders and talking about cash, we're also talking about the likelihood that you may need to modify your existing loan relationships. And in that regard, Ray, what would be some of the differences as you're approaching a lender, particularly on the cycle of forbearance or deferral? How do you differentiate between what is a simple loan modification versus perhaps a forbearance agreement specifically?
Well, the distinction between the two of them is pretty basic. If you're in a loan modification situation, you're generally not in default. You're in good standing with your creditor. Usually we're talking here about loan modifications would be a lender, a bank, for instance. And if you're in good standing, then changing the basic business terms is something that may be more doable. These days, what seems to be the case in speaking with certain banks and just representing parties that are dealing with banks is that banks seem willing, if you're in good standing, to probably let a company go 3 months, maybe in as much as 6 months, interest only. And so maybe pre-planning on something like that, where you go out and you actually approach your bank while you're still in good standing. On the other hand, forbearance comes into play when you're in default and the bank is having concerns. And in that situation, the bank is starting to tighten the screws, put requirements on you that you didn't have before, reduce cure possibilities, and ratchet up the bank's rights frequently in the event that you cannot continue to perform and you actually get worse off. So those are the basic differences between the forbearance and a modification.
Thank you, Ray. So once we have that discussion with the lender, as a business debtor, we're going back to the lender and asking for things. What would be some of the things that a business debtor reasonably could request of a lender in these potentially distressed times? Bob, could you speak to that?
Sure. I suppose in order of priority or in order of preference for the borrower, you might ask for a moratorium on payments for a time. That is a total break on having to make any payments at all. If that's not available, perhaps interest-only payments, as Ray mentioned, some sort of back-end loading where payments are not made presently but passed on to the end of the loan. You might simply ask for a period of forbearance from your lender, particularly if your defaults are not so much payments but not meeting certain covenants. You might just need a break for a period of time from having to meet those covenants. And finally, I guess I would say that if you're in a position to do it, this might be a good time in some cases, and maybe not with your principal lender, but in some other cases to offer to just buy out the loan at some discount. Particularly as banks are being crunched on all sides now, they may be more receptive to those requests than they were a few months ago. The last point I would just make very quickly is when you're negotiating, especially with a bank, banks, as we know, are heavily regulated, that what might seem an obvious solution to you may not be workable for the bank, not because they don't want to allow it, but simply because it affects how they classify your loan, what they have to how much they have to reserve against it, and so forth. So be prepared to be flexible with your lender as you're asking them to be flexible with you. To some extent, you have to work. They have to work within a framework, and you may have to accept some alternatives to make a forbearance arrangement or a workout doable for them.
Indeed. And Bob, as we are looking to what requests might be made and how lenders may react, in terms of how a debtor is actually planning ahead, what would a debtor be thinking as they're possibly contemplating bankruptcy, and why would they be needing to think about certain issues even before filing a bankruptcy petition? Could you speak to those issues, Bob?
Sure. The first thing that I will say about bankruptcy is that the time to plan for how a bankruptcy is going to proceed is before you file the petition, not after. There is a tendency of business owners who are in distress to think of bankruptcy as a remedy for everything that ails them, and that if we can just get a petition filed, there is then endless time to try to right the sinking ship, so to speak. It is critical when you are contemplating bankruptcy to think of a number of things. One, to simply how you're going to cover the costs of retaining competent counsel, competent accountants, and so forth, the professionals that you'll need to survive in bankruptcy. Bankruptcy, it sounds like it shouldn't be this way, but it's an expensive process, so it requires some cash up front. You need to consider secondarily, once you are into a chapter proceeding, especially if you're looking at a Chapter 11 reorganization proceeding, how you're going to operate on, with what funds you're going to operate in that bankruptcy. If you make arrangements with your principal lender in advance, or with some other lender, they may provide you what's called DIP financing, debtor in possession financing, to allow you to operate. If that's not available, will there be enough cash flow from the business in the ordinary course to fund you if you can reach some sort of cash collateral arrangement with your lender? And then the last thing I would say, and this is at least equally important, it's relatively easy to file a petition and get into bankruptcy. You need to have an exit strategy. There's no point in going into a Chapter 11 reorganization proceeding generally if you have no idea how you're going to get out. So if you go into bankruptcy and you have a reasonable plan for, and I often tell business owners, forget about the rules of bankruptcy for a moment. Tell me if certain creditors, certain constituencies would just step back. What do you need to do to fix your business? Do you need to restructure loans? Do you need to reject burdensome contracts? Do you need to shed some unsecured debt so you can use your cash flow where you need it? You need to think about those things and what the plan is, because you're much more likely to be able to sell it and make it happen, and to use the tools that bankruptcy give you if you have a strategy going in, than if you file and then kind of haphazardly try to come up with a plan after that.
Thank you, Bob. So as we're obviously needing to know our exit strategy in advance, we also need to know before we start a bankruptcy filing. Ray, could you speak to the question of what do we need as a first day order from the bankruptcy judge? The court's going to be requiring a lot of things of the parties and of the debtors. What do we need right out of the gate from a bankruptcy court in the way of orders? What happens?
Well, as Bob was saying, I think you need to focus on the way in, on what you need to accomplish and how your business plan and business strategy is going to be effectuated. And that often comes frequently through first day motions and first day orders. When we say first day, it's really not necessarily the first day, it's usually the second day, but still it's pretty fairly early on in the case, and therefore you have to be prepared to file those motions on day one so you can get an immediate emergency hearing. The basic ones that almost every company needs to focus on would be use of their money, cash collateral, or if they don't have enough cash on an ongoing basis to operate, then some sort of a debtor in possession funding, some sort of a loan. So those are of generally primary importance. But where a bankruptcy attorney really needs to add value is to understand the business of the debtor, to understand what unique aspects of the debtor's business must be addressed, in terms of first day motions. Does the debtor have many locations, and are they dealing with utility companies across various counties or states? And therefore, there might be a utility motion you need to file on day one to put in place a process. So utilities won't be able to cut you off at the end of the 20-day period that they normally have under the bankruptcy code if you don't provide adequate assurance to them. So that's a precatory type of motion. There's using your old bank account. Sometimes, usually the U.S. trustee wants you to open up new bank accounts. Sometimes that's just not feasible based upon the business you have, the number of interrelated entities, so you need authority for that. Do you have programs that are in place for your customers? Some sort of reward programs that you want to keep in place. Those might be very important to keep your customer base in line while you're going through the bankruptcy, because that's your source of income. So that's another thing to think about. Do you have payroll taxes and pre-petition taxes that should be paid, that you want to pay, and should those get paid? Do you have insurance premiums coming up that need to get paid? One of the other very important things to figure out is, are there specific vendors that you have that would come under the general concept of a critical vendor? There's no definition in the bankruptcy code of a critical vendor, because frankly, in each instance, in each case, the vendor that would be critical will be different. But generally, critical vendors are potentially single source vendors with whom you really can't operate. Or other vendors that maybe you can find replacements for, but you haven't found replacements for, and now the bankruptcy is upon you. And how do you deal with making sure that you have a continuous flow of whatever inventory or item or service that entity provides? And in that situation, you might come up with a list of vendors that need to be addressed so that they will continue to operate with the debtor going forward. Because for the most part, if you have vendors that are not on a long-term contract, but are just purchase order to purchase order, they don't have to continue to operate with the debtor post-petition, and they certainly don't have to give the debtor any sort of terms for payment. So then you end up in a situation where all of your vendors start requiring you to pay COD, which obviously creates a huge cash need, and it creates a huge cash problem. So that's something that needs to be looked at. Again, some of them are pretty common sense, but part of it is a matter of thinking through what the company's needs really are and how the bankruptcy code can allow you to deal with them.
Indeed. Yeah. Thank you, Ray. And so as we're thinking about how we can have the court assist to compel specific types of performance, we're also thinking about what does the debtor and the debtor's attorney need to be planning in advance of a filing. There's something called a Chapter 11 prepackaged business bankruptcy. And a Chapter 11 bankruptcy is indeed a restructuring of a business. But Barry, if you could speak to the issues of how a prepackaged bankruptcy functions and why it is advisable in certain circumstances, can you take it from here?
Represented a debtor has had a client come in the day or two before a sheriff's sale and say they're going to be foreclosing and selling my business property, or the lender has executed on all my collateral, the sale is tomorrow. And you immediately have to file a bankruptcy petition. A prepackaged bankruptcy petition is where some party has really assessed their situation long before the need to file bankruptcy. They speak with their secured lender to make sure that the lender will work with them in a Chapter 11 and provide them with the cash collateral agreement and financing to move forward. Or if they can't make a deal with their current lender, then they find another third-party lender that will work with them. Once they have that lined up, it's a little bit easier to go to their various classes of creditors, tell them, we have the financing lined up, this is how we propose to move forward, we need your support in voting in favor of our plan. And it's basically, we've got everything in line as of the date of the bankruptcy filing, and we're going to go into bankruptcy, we're going to get the cash collateral order, we're going to have our financing, and we're going to get out of bankruptcy in a few months if possible.
Thank you, Barry. That was very helpful about why we would contemplate a prepackaged as opposed to last-minute bankruptcy. If we're moving then into the issue of how we would address individuals in bankruptcy, here we're talking in the context again of a business bankruptcy, but a business obviously has individuals behind it, the owners, the principals, the shareholders. Those principals can also be affected by a bankruptcy filing, perhaps quite detrimentally, and very often attorneys need to consider those effects as well. Don, would you want to speak to the issue of how you would have special issues that principals should perhaps beware of when looking at their business bankruptcy? Don?
Well, sure. This is a very sensitive topic, to be sure, as a business, and the principals, maybe it's a single owner or a family that operate the business as majority owners, as they face the disaster of inevitable bankruptcy. Obviously, you want to protect yourself and Aunt Sally, who put money into the business to keep it afloat for a while. All of those kind of things you want to give preference to. You will be found out ultimately, however, because of the clawback provisions, preference claims after the bankruptcy is filed. As you go that direction, however, you still can pay yourself for the work that you're doing, the value you're giving the company as the CEO, and other people maybe in the family who are also employed. But it is a sensitive dance back and forth, because the trustee and the unsecured creditors are going to start looking after the filing to see what you have done in the recent months up to a year with the money, and what preferences you did give to insiders.
Yeah, well, thank you, Don. And as we're considering the institution of a bankruptcy upon a principal, we're also talking about the perhaps significant personal risks that the individual principals may be undertaking, because after all, those principals may have had specific obligations personally with respect to the business's obligations. Ray, the question here is, what are the business obligations for which a principal may have personal liability?
Well, there are, I guess, a couple that I can think of pretty readily. Well, the first would be, of course, if there's a guarantee. So obviously, if the principal signed a guarantee in favor of a lender or other creditor, then there's a personal obligation there. There also can be personal obligations for insiders, principals, significant shareholders, in the event that withholding taxes aren't paid. And the same sort of analysis goes into a determination as to whether insiders qualify and become liable if payroll and payroll-related benefits are not paid. So there's a whole series of things that principals need to focus on, both coming up to and getting into the bankruptcy, to make sure they limit their liability as much as possible. As it relates to a guarantee, a company can always pay a valid debt. There's nothing wrong with that. And if the company chooses to pay the debt that's guaranteed by the insider, that's certainly permissible. It very well may open up the insider to some sort of a preference clawback later on, as Don was suggesting. But then again, sometimes the insider needs to look at which party would you prefer coming after you. A creditors committee in terms of a preference, or the bank in terms of the guarantee. And sometimes the answer is not so clear. But the bottom line is that insiders have to really be focused on the types of obligations that the company has, and which of those obligations the insider may in fact be liable to pay personally. Now, obviously,
go ahead. Sorry. Yeah.
Go ahead.
When you have those personal obligations, how do you structure them as an individual, perhaps not looking out for the business's interests, but looking out for your own interests?
Well, in the beginning, before you even get into certain obligations, it might be if you can get loans that do not require personal guarantees, or loans, better yet, that or even non-recourse, so they're just directed at the collateral that the bank may have, then obviously that puts the company and then the insider in the best position. In terms of the other things, when taxes are due, withholding taxes are due, make sure the company pays in the ordinary course. Sales taxes, make sure that they are withheld and paid over. Payroll, make sure your employees are paid. I mean, that's sort of common sense, because most employees won't work if they're not getting paid. But there are those situations where employees don't get paid and will still work for a period of time. And so those are the things that you need to think about when you're sort of walking through the process and you have a company that has a certain amount of problems that you can see slipping into an insolvency situation potentially.
Yeah, so as you're working with your attorney then, Ray, your attorney may also have obligations, particularly here, how can an attorney potentially serve two different masters, being both the debtor business and its individual principal?
Well, it really can't. It's certainly not in an insolvency situation. That's like a cardinal rule. You can't both represent an insider as well as the debtor in a Chapter 11 or Chapter 7, frankly, for that matter, because the interest, it's rare, I guess. In a Chapter 7, there may be interest, maybe a line, so it may not matter. But certainly in a Chapter 11, you can't do that. And I think that one of the things that counsel needs to think about is there's almost always a period of time before the filing of the bankruptcy where you're representing the company or / the insider or insiders. And so in those situations, you really need to think through to what will be the case when you file the bankruptcy. Because if you file the bankruptcy on behalf of the company, you as the attorney, in order to get employed, have to provide information as to related parties that you may have worked for prior to the filing of the bankruptcy. And so you put yourself into a potential situation where you have a conflict because you had just represented the insider and now you're representing the company. And that's certainly something U.S. Trustee's Office is going to want to know. So I think when you first get into the relationship, before you choose, you should think strongly about which candidate as a client you would rather have. Sometimes you'd rather have the insider because the insider has all the value and the assets and the ability to move forward, and the company is essentially just dead man walking, so to speak. Sometimes it's the opposite. The company has real alternatives and viability, and it's the insider that has all sorts of personal issues and problems and claims and debts, and therefore you would go with the company. So those are I think that's the general analysis that I go through when I'm asked to come into a difficult situation. And I frequently will also make sure that the insider understands that I can only represent either the insider or the company, but not both.
Thank you, Ray. So if we're talking about that insider's analysis and looking from the business insider's perspective, perhaps there's some significant issues that Don, you could address in the question of when must a business insider in fact protect the business's creditors rather than the shareholders of the business? Don?
Sure. Well, it's easy to conflate the issues Ray's talking about as counsel for principals and the bankruptcy, or the bankrupt business, and the insiders, the principals of the business themselves, who have a lot of different hats. They're the management team, maybe if it's debtor in possession and they continue operating the business. They're principal owners, and so the important point and the obvious point is once you file, and also they were the principal owners. So the obvious point once you file is you are no longer looking after the interest of the shareholder. Your job, to the extent you retain control of the business in bankruptcy, is to marshal assets for the benefit of the creditors. And it's not very likely, I should think, that you would find shareholders coming out of a bankrupt business with much left over, as for instance General Motors way back, if you recall, in the 2007-2008 crisis, those shareholders all kind of disappeared.
Yeah, indeed. So thank you, Don. Thank you for speaking to that. We're going to move on to our next topic now, which is about the insolvency alternatives to bankruptcy and how to manage insolvency in a variety of circumstances with outcomes that are potentially quite different than just a straight bankruptcy. And Polly Gibble, thank you for your patience as you're finally joining us here. But panelist Polly, if you want to answer the question of the different types of bankruptcies that are possibly in our realm and how we would navigate these.
Okay, thank you, Peter. Well, basically, there are 5 different types of bankruptcies, and they're organized by chapter under the Bankruptcy Code, which is, of course, the federal statute. First, I'll talk about Chapter 7, which can be either filed by an individual or a business entity. Chapter 7 is basically a liquidating case where a Chapter 7 trustee is appointed by the court to gather and assets, liquidate them, and distribute them to creditors according to the priorities under the Bankruptcy Code. In the case of an individual Chapter 7 debtor, they have the opportunity to exempt certain assets from liquidation and get a discharge. Then we move on to Chapter 13, which is basically for wage earners. It's for individuals. And the debtor proposes to pay his projected disposable income into a plan over 3 to 5 years. The Chapter 13 trustee would be appointed, who oversees the case and also distributes the plan payments that the debtor makes. Then there's a Chapter 12, which is very similar to Chapter 13, but only available to family farmers and family fishermen. And then there is Chapter 11, which we've been concentrating on, which can be filed by either an individual or a business entity, in which case it's the reorganization chapter, which allows the debtor to propose a plan to keep its business and pay creditors over time and then get a discharge. And there are special provisions for small businesses which have recently been amended and which we will talk about in more detail later. That's known as Subchapter 5 of Chapter 11.
Thank you.
Finally,
yes.
There's Chapter 9, which is for municipalities and other local governmental agencies. And then there's involuntary bankruptcy petitions, which may be filed against an individual or business, generally by creditors. It would either be filed under Chapter 7 or Chapter 11. And there's special rules about what type of creditors can file and how many have to be filed based on the number of creditors that exist. The basic issue will be the petitioning creditors have to establish that the debtor is generally not paying its debts when they become due. But beware to the petitioning creditors, if the case is dismissed by the court, then judgment can be entered against the petitioning creditors for costs and attorney's fees. And if the court finds it was filed in bad faith, then judgment can be entered against them for punitive and actual damages, which can become quite substantial.
Indeed, yeah. So watch out for involuntary bankruptcy if you're a creditor, even a creditor who's looking to make some aggressive action. That can backfire potentially. Polly, could you also speak to the issue of outside of just that realm of bankruptcy, what other ways could creditors perhaps benefit, perhaps through an assignment to the benefit of creditors? What is that, Polly?
The assignment for benefit of creditors is a remedy created by Pennsylvania statute, which you don't really see happen very often. It's analogous to a Chapter 7 and a liquidating receiver, but it's the debtor who initiates the proceeding by picking an assignee to whom he voluntarily transfers all of his assets. The assignee then holds the assets in trust and liquidates them and distributes them to creditors. It's less expensive and quicker than a Chapter 7. And here the assignee will run the show, but unlike bankruptcy, you do not get the benefit of an automatic stay and no ability to reject unexpired leases, executory contracts. And you do not have oversight by a trustee. So there wouldn't be any preference actions, although there still could be fraudulent transfer actions.
So if you're having other creditors file lawsuits against a debtor, that perhaps is not the way to go because that would mean with the automatic stay not applying, those creditors could proceed in state courts. but perhaps there's still other remedies that they could pursue, or rather, perhaps the issue of receivership. Barry, would you want to speak to receivership and how that would be commenced?
Thank you, Peter. Unlike the bankruptcy types that Polly talked about, chapters 7, 11, 13, etc., these are all voluntary filings, steps taken by the debtor. A receivership is something different. A receivership is generally an action that is started in the Court of Common Pleas of the county where the business is located. And in my experience, it's generally started by a bank who has lost faith in whoever is running the show in a business or feels there's been some fraud or dishonesty. So the bank comes in and asks for a receiver to be appointed. When the receiver is appointed, the party who runs the company is no longer in charge. The receiver is. It's also used in situations where there might be 50 shareholders in a business. They can't agree, and they want to just one of them wants to liquidate the business, get it over and done with, or maybe try to buy out the other party. So they bring a receivership action. Once the receiver is appointed, it's almost like being a Chapter 7 trustee. The idea is to basically figure out how you're going to liquidate the assets for the very best price. One of the differences is that as a receiver, you really don't have to go into bankruptcy court and file applications to employ professionals such as realtors who are going to sell property, and you make the case move a lot more quickly. You don't have to go back to court for many things because the receiver is really just in charge of the business and liquidating everything. The one exception to that is if you have in a 50-50 shareholder situation and it becomes very contentious, you might want to take a little bit more action and file some motions before the court so that either of the parties can come in and file an objection if they think you're doing something improperly or wrong, just so you are protected as a receiver.
Thank you, Barry. If we would then look at how outright liquidation could be compared to bankruptcy. If we would talk about a voluntary liquidation, what is a voluntary liquidation that would occur outside of bankruptcy, Barry?
Basically, it's just the party has pretty much decided they can't continue on with their business. They will just indicate to their lender and to their unsecured creditors that they're unable to carry on. I generally and they'll liquidate the assets on their own. In cases where I've represented people doing voluntary liquidations, we send a letter to the unsecureds indicating we appreciate the relationship we've had. We're going to sell the assets. We do have to pay the secured creditor who holds the collateral. And if there's any funds left over, those unsecured creditors will be paid on a pro rata basis.
Thank you, Barry. That was helpful to hear about voluntary liquidations and how that could occur. Moving to our next topic, if we would look, Polly, on the issue of how a small business in particular, would perhaps most benefit from bankruptcy provisions. I understand that there's a new subchapter, the Small Business Subchapter 5 for bankruptcy. Could you tell us what is that? What is new and what is it?
Okay. Well, as has been alluded to, Chapter 11 typically can be very expensive, time-consuming, and overwhelming for small businesses. So there was a small business provision in Chapter 11, but there were still obstacles for small businesses. So Congress recently enacted the new Subchapter 5, and it provides a streamlined and less expensive way for small businesses to reorganize under Chapter 11. So it's still a Chapter 11 case, but it's proceeding under Subchapter 5. It became effective on February 19th of 2020. And originally, it was available to a business who owed less than $2,725,625 in non-contingent secured and unsecured debt. But as part of the CARES Act, because of COVID-19, Congress increased the debt limit to $7.5 million for 1 year effective March 27th of 2020. After that year, the debt limit will revert back to the 2.725 million. Oh, go ahead.
Yeah. So we have some of the parameters for who could potentially qualify. We're talking about debtors that would have not more than a little less than $8 million in debts that are at issue. But how does a business then proceed in that subchapter 5? Who would, for example, who would oversee it, and after we get the qualification?
Well, either an individual or an entity may make the election to file under Subchapter 5. The election has to be made when the Chapter 11 petition is filed. To qualify under Subchapter 5, at least 50% of the debtor's debts must be business related, but there's no requirement that the debtor continue operating the business. Under Subchapter 5, only the debtor may file a plan, but it must be filed within 90 days. And the plan must propose to pay all of the debtor's projected disposable income over a period of 3 to 5 years. And then the sum will be distributed to the debtor's creditors over the life of the plan.
So how is that then administered by the court or by a trustee, or who would handle that administration?
Well, a Subchapter 5 trustee is appointed by the court, and the role of the trustee is to help facilitate a consensual plan and generally oversee and monitor the case. The status conference will be held before the judge within 60 days of the date the petition is filed, and the trustee will attend that status conference. 14 days before the status conference, the debtor must file a report which details the efforts he made to obtain a consensual plan. Now, the role of the trustee differs depending on whether it's a consensual or non-consensual plan. In a consensual plan, the debtor...
Consent of the other creditors,
yeah,
is what you mean by consensual. Yeah, sure.
The debtor will get a discharge upon confirmation, and the Subchapter 5 trustee will be discharged of his duties. At that point, the debtor then makes the plan payments directly to the creditors. In addition, the automatic stay will terminate once the plan is confirmed. When you have a non-consensual plan where creditors are not agreeing to the terms the debtor proposes, the trustee will continue with his duties, and the plan payments will be made by the debtor to the Chapter 5 trustee, who will then distribute them to the creditors, like Chapter 13 trustee does. The debtor gets his discharge when the plan payments are completed, and in addition, the automatic stay, which prevents actions by creditors against the debtor to collect pre-petition debts, continues after confirmation and terminates then when the debtor gets his discharge or if the case is dismissed before that time.
Thank you. Thank you, Polly. Barry, if you could speak to some of the ways that a subchapter 5 is perhaps similar to other types of bankruptcy. Could you address that?
Well, I'm going to talk a little bit more about how it's dissimilar, to be honest with you, Peter.
Sure, fair enough.
When a Subchapter 5 petition is filed, the debtor must file a balance sheet, statement of operations, cash flow statement, and a federal tax return. So that information is available right at the beginning of the case. One of the important differences from a traditional Chapter 11 case is that there are no quarterly fees paid into the U.S. trustee system. This makes it a lot cheaper for the debtor to operate rather than having to pay a portion of the money that runs through their account over to the United States trustee. So that's a huge savings for a debtor. One of the other provisions that is new that we haven't seen before is that a debtor would have the ability to modify a mortgage on their personal residence if the money that was borrowed from the bank went into the business and was not used for the purchase of the rest of the residence. So oftentimes you see lenders wanting to take back additional collateral in a home and things like that. That's going to help a debtor out in that situation. There is no disclosure statement filed in a Subchapter 5. You just file the plan, so you don't have to have a hearing on the disclosure statement. You can just go right into the plan. The biggest deal, quite frankly, is the fact that there is no absolute priority rule in the Subchapter 5 case. In an absolute priority rule basically indicates that it requires that all class of creditors be paid in full before the equity owners can retain their interest in a business, and that's pretty difficult to happen. In a Subchapter 5, as long as all of the disposable income is paid into the plan over the 3 to 5 year period, and as long as the plan does not unfairly discriminate against creditors, the shareholders can retain their interest in the business when the plan payments are completed.
So indeed, in that regard, a small business would potentially do better in a Subchapter 5 than other types of bankruptcy. Is that right, Barry?
Absolutely. I think that we will see a lot of Subchapter 5 bankruptcies in the not too distant future.
And it would be because of that ability to retain some of their equity interest and have it paid back.
Yes, pay a lot less in the way of costs and things of that nature.
Very good. Thank you for that overview about Subchapter 5, Polly and Barry. We're going to move on now to talking finally. Our final topic is about the context of out of court workouts. These are circumstances that would be beyond the scope of a bankruptcy and perhaps would be entirely without supervision of a bankruptcy court. But what would be some of the pluses and minuses, Polly, pluses and minuses when comparing a formal bankruptcy and using that measure that would be overseen by the courts versus perhaps the more informal out-of-court workout? Could you speak to that, please?
Probably the biggest benefit of
There, we hear you. Yes, thanks.
Okay, hi. Yes, probably the biggest benefit of filing bankruptcy is the automatic stay, which, as it's referred to, automatically goes into effect as soon as a bankruptcy petition is filed, and it prevents creditors from taking any action to collect a pre-petition debt against the debtor. So this gives the debtor a breathing room and buys time for the debtor to begin to work with his creditors, which he should have already done beforehand, but to get the bankruptcy rolling. Another benefit of the bankruptcy is that it resolves all of your debts at once and provides an individual debtor in the 7 and all debtors in other chapters with a discharge of debts. Another benefit is that because of the provisions of the bankruptcy code, it makes it easier make it easier to get a debt modification or cram down of debt.
What is a cram down, Polly?
That is when if you have a secured creditor, you're able to get the value of the claim down to the value of the secured property. It's not always available, and it depends on what chapter you're filing under, but that is generally what a cram down is. The benefits of the out-of-court workout are that, most importantly, it's usually much less expensive and quicker. It's informal. You do not have to include all creditors, which can be a drawback because you're not globally resolving everything for yourself. Another benefit is that there is no oversight by a trustee, the U.S. trustee, other creditors, or the court. And there's no need to worry about preferential transfer actions being filed.
Yeah.
That's something that only a trustee can do, or the debtor or creditors committee in certain cases in a bankruptcy.
Thank you. Thank you, Polly. So if we're looking at the expenses or the costs of contemplating bankruptcy filing versus perhaps going our own more casual or informal out-of-court workout scenario, Barry, could you speak to the difference in expenses and how that a debtor could analyze that? Here, I'll unmute you. Sorry, now you're unmuted. Thank you.
Okay. The first big thing is attorney's fees, quite frankly. If client's going to get into Chapter 11, you have a client for a number of years, more than likely, and you have to get a very substantial retainer. In a out-of-court workout, you can generally work with your counsel or your accountants, whoever you're dealing with, throughout the trying to negotiate with your creditors. You don't have to pay the quarterly fees that you would have to pay if you're in a Chapter 11. If you're in a Chapter 11 and there's a creditors committee appointed, you won't have to pay fees for the creditors committee, for their counsel or their accountants. And so if you can do it out of court, it's obviously much, much less expensive than if you are in bankruptcy.
Thank you, Barry. And before we get to our final question, I just wanted to point out to the attendees that if you have any questions, this is the time to ask them. No need to hold back further. You can text them to me by the chat that is at your icon at the bottom of the screen. You can text those to the host, and I will see those and will bring those to the attention of the panel. With that, Barry, could you tell us, how does someone commence an out-of-court workout? If you're not needing to file a bankruptcy petition, if it's something relatively informal, how does it even begin?
Well, it takes a little forethought. I think the party needs to go to their lender, tell them they'd like to be able to continue in business, that they're going to speak with their unsecured creditors to see if they will cooperate. You would like to line up whatever financing you might need to continue to move forward. And then at that point in time, generally what I do, if I'm trying to do an out-of-court workout for a client, is we contact all of the unsecured creditors and try to educate them as to why they are better off working in an out-of-court settlement as opposed to a bankruptcy case. And that would be because of the expense involved, administrative expenses, which all get paid before any money filters down to an unsecured creditor, the timing for distribution or payment, which would be way, way out in the future if it's going to be in a bankruptcy case. So we try to explain to them why it's much better to work with our client in an out-of-court workout as opposed to them filing a bankruptcy petition.
Great. Thank you, Barry. Well, we're going to turn it over to questions now. We have our panel to thank. Thank you to Ray Lemish, Polly Gibble, Barry Salati, Bob Ponce, and Don Hess for being our panelists here today. And if you do have questions or comments, please feel free to text those to the chat. We haven't actually gotten many questions aside from Larry Keating asking me, and I'll call you out, Larry, because I know you won't mind, whether I bike to work today. And Barry, in fact, I could walk down the stairs because I'm in my own basement. I am unfortunately not here at the Golden Gate Bridge, as you see in the background. That's just an image. Folks, if you have any questions, we're happy to address those. Otherwise, I will just turn it back to the panel to comment about anything they're seeing circumstantially right now with the COVID-19 pandemic relating to the specifics of a bankruptcy or financial insolvency questions. Oh, I do see one question here. I'm sorry. Let me just interrupt. So the questioner is asking, is a Chapter 5 like a Chapter 13 bankruptcy for business? So that's the question. Barry or Polly, would you like to take that? Does it compare to a Chapter 13 for businesses?
Polly, go ahead.
Okay. Well, it is very similar in that Subchapter 5 trustee is appointed, and you propose a plan to pay your disposable income over a period of 3 to 5 years. So yes, it is very similar. Now, as I said before, depending on whether the plan is consensual or non-consensual, in the Chapter 13, the trustee remains duties throughout the course of the whole plan, which in a Subchapter 5, if it's a consensual plan, the Subchapter 5 trustee will be relieved of his duties once the plan is confirmed, and then the debtor pays the plan payments directly to creditors. So yes, it is very similar to a Chapter 13 in that respect. Do you have anything to add, Barry?
No, I think in a Subchapter 5, there's a trustee appointed to sort of oversee and watch what you're doing. In the Chapter 13 case, when you get a case confirmed, all they're doing is collecting the cash, to make the distribution to creditors. So.
Very good. Thank you. And I'm not getting any other questions, so I would interrupt if we have further questions. Do the panelists want to make any comments about the, oh, I'm sorry, here's another question. The question here is, what is the consensus from the legal experts on the expectation of the magnitude of bankruptcy filings for the coming quarters, for Q2, Q3, Q4? Do we have any projections? Has anyone heard anything?
If it's anything like 2008, there was a lag between the onset of the crisis and the real push of bankruptcy filings. Right now, as a number of the panelists have mentioned, pretty much everybody's in trouble. Banks are trying to work with everybody as it should be. It will take a while for the cases that can, that are strictly tied to COVID-19 to separate themselves from loans and businesses that were problems before anybody ever heard of COVID-19. So I would anticipate that it'll be late this year and probably into next year before you'll see a real flood of filings that some are predicting, and that I know a lot of the law firms that do debtor side bankruptcy work are gearing up for.
Thank you, Bob.
I would
Does
have to
anyone
agree
else?
with
Yeah,
that.
go ahead.
Yeah, this is Ray. Yeah, I would agree with that assessment. I think there's going to be a lag time, as there was in 2008. And I think that part of it is that there are a lot of recovery processes in place and a bunch of loans. And one of the things that's going on right now in Chapter 11s is whether or not a Chapter 11 debtor can get a PPP loan, because that's administered through the SBA, and the SBA general guidelines provide that no loans can be made to an entity in bankruptcy. So there have been a variety of legal battles over that already in different jurisdictions, and it seems to me there's a growing wave of bankruptcy court judges who are entering injunctions against the SBA and precluding them from not lending, I guess, at this point. So, not all of them, but there has been a wave of that. And so I think that that in and of itself will create some interesting, I guess, dominoes falling in terms of Chapter 11 being used as a viable alternative for companies that have been hit with the COVID-19 problems.
Indeed. Anyone else on the panel?
I agree with Bob. I haven't seen anybody come in to me and say, hey, I've got to file a bankruptcy petition, right now. A lot of people, though, are coming in and saying, well, let's talk about the future. What could happen to me? What rights will I have? What rights, don't I have? So I think there's a lot more thinking about it right now and trying to plan than in the normal course of bankruptcy filings.
Yes, and I agree. And I know, having spoken to the local bankruptcy court, that they have not yet seen a wave of filings, and they're expecting too that it will just be a while. And a lot of it will depend, I guess, on how the recovery actually takes place. What happens? Are people going to, in terms of retail and restaurants, things like that, are people going to rush out and go out to eat, go to a retail store once they do reopen? So there is a lot of uncertainty ahead. And also, I agree about all the loans and different types of packages that are available to people right now in businesses because of COVID-19. That's generally just letting businesses and people tide the course and get through it for now. So I guess we'll all have to see what happens, but I'm sure there will be an increase in filings, probably, by the end of the year, maybe a little bit before.
Yeah. Well, thank you to our panelists. Again, thank you for your time and for your expertise here today. This has been our Navigating Uncertain Finances webinar on non-bankruptcy and pre-bankruptcy planning alternatives for small businesses. Hopefully you have had an introduction to some of the concepts in bankruptcy and in creditors or debtors' rights in regards to the current situation with financial uncertainty. And above all, folks, be well during these times. We hope you're taking care of yourselves and each other. Thank you. Goodbye.